Let's look. Good afternoon.
Good afternoon, Mr. Shoeto.
We have Mr. Nokoya here. All right.
SBL committee, are we ready to start? Please, can we start?
Apologies for starting a little behind schedule. We had some technical issues that we're trying to resolve. And so without further ado, once again, I bid you good afternoon. Welcome to this webinar on evidentiary standards and burden of proof in international arbitration, myths, practices, and pitfalls. It's a webinar jointly hosted by the NBA section on business law and the Chartered Institute of Arbitrators, Nigeria. On behalf of the chair of the Arbitration and ADR Committee, Mrs. Soibi Ovia, I want to bid everyone welcome and thank you for joining. And at this time, let me hand over to our hosts for today, starting with the chair of the SBL, Mrs. Ozofu Latunde Ogemudia, for her opening remarks.
Thank you very much. Good afternoon, everyone. We're very delighted. Good afternoon, Leonard Silk.
Good afternoon.
And good afternoon, Mrs. Adegomire, and everybody from the CIR Association. It's really a joy to us at the SBL to host this collaborative webinar, and the turnout for today's event shows that it's very timely and there's a lot of interest. We usually try to keep to 1 hour, so my comments are not long. It's just to welcome everyone, to thank Mr. Ojo SAN for agreeing to be our guest today, and to thank the CIR for helping to put this together, and we look forward to more opportunities to collaborate. Thank you.
Thank you, ma'am. And we also have remarks from Mrs. Olushola Adepomere, the chair of the Chartered Institute of Arbitrators, Nigeria.
Pleasure. It's a pleasure to be here and on this important collaboration. I call it important collaboration. We've been talking. I think there's an echo.
I think it's because you have two devices on. You have two devices on.
Together. And I'm happy that we have started actually doing something together. Thank you, Ozofu. We finally got there, and I know this is the beginning of many other things. And so we're really thrilled to collaborate with the section on business law to deliver a webinar on this all-important topic. What are the myths, the practice, and the burden of proof? Evidence is the lifeblood of anything, is the lifeblood of litigation, and it's the lifeblood of arbitration. It determines how tribunals reach decisions, how the decisions withstand scrutiny. If there's no evidence or burden of proof, it's very difficult to prove anything. And so this picture is actually more complex than we can think about. There's so many things there are soft laws that guide arbitration, even though the Evidence Act says arbitration does not, the Evidence Act does not apply to arbitration, but in international law, there are all kinds of soft laws and that we can use in evidence in arbitration. And so today, this webinar will explore some of these, the soft laws, and how tribunals and practitioners navigate these tensions. Of course, 1 hour is not enough for this. This is almost a course. So I believe that this 1 hour is just a taster that will then bring you to say, okay, I want to know more. I want to get more involved. I want to do more in international arbitration. Because at the end of this webinar, we should be able to separate the myth from the reality and strengthen evidentiary practice in arbitration. And at the same time, we do not lose sight of efficiency, cost effectiveness, and procedural fairness. These are all very important. I want to wish you a most fulfilling time, and I look forward to us doing much more together, much more. Thank you very much. We're really happy to collaborate with SBL. And thank you, our learned SAN. Thank you very much. Thank you. You and your partner, the cyclists, I'm happy to see both of you here. Mr. Shoeton. Thank you, everybody. I can't mention everybody, but Mr. Endurance, you've done a lot of work. Thank you so much. And everybody here, and especially our chair, Madam Ozofu, thank you for still pursuing this, our collaboration. Thank you very much. Let's all go ahead and enjoy. I hand over the mic.
Thank you very much, Ma, for your warm remarks. So moving very quickly, again, I apologize. We had some technical issues, so that is why we did not start immediately as scheduled. But moving quickly now to a brief introduction of our speaker. Our speaker this afternoon is Mr. Sheila Ojo, Senior Advocate of Nigeria and a Chartered Arbitrator. His resume is intimidating, to say the least. And he had told me that he doesn't really like being described in so many words. But suffice it to say that he is an expert in the field He has served as counsel, as party appointed arbitrator, sole arbitrator, and presiding arbitrator in a tribunal in various arbitral references. So, Learned Silk, sir, we are most grateful to have you with us this afternoon.
Thank you for having me.
Thank you, sir. So, to get into it quickly, we are discussing evidentiary standards and the burden of proof in international arbitration, myths, practice, and pitfalls. From your experience, do Nigerian counsel tend to approach burden of proof in arbitration as if they were still in court? And what practical problems does this create?
Thank you very much for the question. Let me start by thanking the section on business law for inviting me over to take this role. There is an assumption that I have attained a level of competence, so the pressure is very heavy on me. I do not take it for granted, but notwithstanding that, and I say this with all sense of humility, I look forward more to learning from the audience and having a symbiotic experience with you all as we go through this conversation. The time is too short to speak thoroughly on the subject, but I'm hopeful that at the end of the day, we would have gained more than we had when we start. So I enjoin participants to please lend themselves to it, make contributions. No contribution is irrelevant. No question is irrelevant. I've had the privilege of sitting as chair of the branch training committee now. I've been in the faculty for almost 2 decades, and every time we have these sessions, I always come out the better for it. So thank you for having me. Now to your question, about how burden of proof counsel approach burden of proof issues. I think the starting point is to understand that arbitration is a party-driven process. What that means for purposes of the dispute resolution activity is that parties determine how it will go. So parties choose the rules, and parties determine how the matter, the burden of proof, and everything that pertains to arbitration is going to go. What I always say is that practitioners have to develop a mindset shift. Litigation is not the mindset you want to take into the arbitration room. And as we'll come to find in the next couple of minutes, there are arbitration is more nuanced than litigation is, and there'll be need for us to approach it different from the way we approach litigation. It's a self-regulated process. The burden of proof pretty much can be the same as what you have in your typical litigation. However, it is not exactly the same in terms of how you discharge the burden that is on you. So I'll just answer that question briefly that way, and I hope that in the next couple of minutes we'll dig deeper, that we may search into it.
Thank you, sir. As you mentioned, it's a party-driven process, and we should not approach it in the same manner as we would approach litigation in the traditional court system. So in arbitrations seated in Nigeria, how much weight do tribunals actually give to Nigerian evidentiary principles, such as those under the Evidence Act, compared to transnational standards? I mean, we know that the Evidence Act excludes its application from arbitration, but that's what evidentiary principles under the Evidence Act, that's what weight the tribunals actually give to those principles.
Sorry, there's a freeze. Can you hear me? I don't know if the network is...
Yes, I can hear you.
End or your end. Can you hear me? Okay, good. Okay, good. So from where I'll pick it up from where you ended, the fact that the Evidence Act does not apply. The Evidence Act is self-exclusionary, meaning that if you go to the Evidence Act, you actually find a provision that says, don't take me into the arbitration room. And that is section 258. So how does that pan out in practice? You have to understand, arbitrators understand that because the Evidence Act is not applicable, they are dealing with a very flexible dispute resolution mechanism. So the strict rules of evidence that you find in the Evidence Act do not apply. And that is because for purposes of an arbitration hearing, you're supposed to have a less rigid approach to the dispute resolution process. So generally, tribunals don't take to the strict rules of evidence. I remember when I was first getting into the arbitration space, I appeared before a tribunal where I kept on citing the Evidence Act and said the ignorance was palpable, and I was put in check by the tribunal at that time. So it doesn't apply, meaning that tribunals adopt a more flexible approach to determining issues of admissibility and relevance. So the fact that somebody is bringing a photocopy, which ordinarily in a courtroom setting, you will say, oh, it has to lay proper foundation in light of certain provisions of the Evidence Act. In an arbitration hearing, that does not work. You send in bundles which are made up of photocopies anyway, so you've already crossed that Rubicon of what the Evidence Act would have required of you in that case. So, but generally what you then find in arbitration is this: if the Evidence Act does not apply, so what then applies to taking evidence? There must be an objective standard. There must be a set of rules that we choose to apply. And it is in this context that parties often refer to the IBA rules on taking evidence. Now, the IBA rules on taking evidence, we'll talk about it momentarily, but just note for purpose of this, me answering this question, that it is soft law. It is not hard law, but they serve as a useful guide in assisting tribunals and in determining how evidential burdens are discharged. So that is one thing, because even a desire to be flexible, it's bridging the gap between legal cultures. So it provides a more flexible approach. And if parties are keen to have some set of rules that guide them, the IBA rules generally is a reference point in determining how evidential burdens are discharged.
Thank you, sir. I like that you mentioned the IBA rules in answering this. As you mentioned, we'll come to that because I was going to bring up that subsequently in the course of our discussion. But before we get to that, the principle that he who asserts must prove is often invoked in arbitral proceedings by counsel. So where do Nigerian practitioners most commonly get its application wrong in arbitration?
For me, they get it wrong whether in arbitration or in litigation in the same way. The principle, he who asserts must prove, simply means that whoever asserts a positive fact has the burden of establishing that fact. Meaning, if the dispute is over who owns the telephone, I say I bought it, and the other person says, no, I did not. I am the one that speaks affirmatively to the fact that I bought it. Therefore, how do I demonstrate that I bought it? I will give you a receipt. The other side that says I did not does not have to prove that you did not buy it unless and until I have put that receipt in, and then the burden shifts. Meaning also that as a matter of law and procedure, you are not required to prove a negative assertion. Now, this is very often where counsel and indeed courts, I must say with due respect, get it wrong. I just read a decision about 2 days ago where the issue whether a document was delivered, certain things would have been done. We did not receive it, and the burden was put on the company to prove that they did not receive it without the person tendering it showing some level of some proof of receipt or otherwise. So this is an area where it is often missed. Now, but then understanding that there are also some intricate parts of it where a fact is within your peculiar knowledge, in which case I wouldn't know, and you are the one who has knowledge of that fact. It applies to you. Now, we said the Evidence Act does not apply, which means it must be flexible. But we must always understand that the rules of evidence always come to play. So if you're resolving a basic dispute about something that transpired somewhere, and somebody comes to tell you a story about what Femi Onokoya said, and it is not Femi Onokoya who's saying the story, typically, you know, that is what you call hearsay. Now, in practice, that's in arbitration, even though you will be able to say, oh, the courts will not apply the Evidence Act, but there is a rule that guides you and tells you that the more believable person will be Femi Onokoya himself, not somebody that is coming to report to me what Femi Onokoya said. So in arbitration, the other place where they sometimes get it wrong is in compilation of the documents, because the documents are intended to prove or disprove certain allegations that you've made in your pleadings. So usually arbitrators give you directions as to how to compile your documents, and you must do them in a particular way, properly paginated, properly written out, and properly bundled. Now, most times at trial or at the evidentiary hearing, what counsel tend to assume is that because they've piled up a bundle of documents and have given it to the tribunal, then the tribunal will have to go and read it without necessarily taking the time to refer the tribunal to what document is relevant to what assertion that they're making. And that is another place where they always falter. So I once had the experience of an arbitration where the bundle of documents was going to about 300 pages, and it was not in compliance with the procedural order at all. All they did was just to number the page. So when the respondent argued in his closing arguments that I should look at it, I had to fall back on that. I did my level best. But if you really know that a particular document bears you out on an assertion, it is your responsibility to then put it out before the tribunal. So this is another area where I think many counsel tend to falter, to assume that we've put the documents there, the tribunal will go and read everything. The tribunal will read everything, but may not be able to ascribe to those things the interpretation that you want to ascribe to it, because you know your case better than the tribunal. And the tribunal some tribunals may be perfunctory, others may yet be detailed, but still make the same mistake as the tribunal that was perfunctory. So, I mean, that's what I see as the basic errors that counsel tend to fall into.
All right, thank you, sir. Now your answer has brought up another question to my mind. When I'm talking about putting documents together in a bundle for the evidentiary hearing in the proceedings, it goes to the roots of the case, of preparing your case for presentation. So in that regard, what are the most common evidentiary pitfalls Nigerian counsel fall into, especially when dealing with document production, witness statements, and cross-examination? I'm sorry I'm putting this together. I know it's a bit loaded. I don't know if you'll be able to take that is because it flowed
Yeah,
from your answer.
I'll do my level best, and please, by all means, feel free to bring me back if I derail. Document
Very well,
production
sir.
is interesting because your case starts with your pleadings, because it is the state of your pleadings that will tell you what documents you need to present to substantiate the evidence. So one of the areas that you need to look at as counsel is in how you draft your pleadings. There will always be document production. There is basic document production. We all have gone to court. We all have prepared statements of claim, statements of defense. We are told to front load our documents. So that is your basic barest minimum standard of disclosure that is required of you. In doing so and in crafting your pleadings, you need to be sure that you don't speak in too vague expressions, or will rely on all those documents that are relevant. What does that mean? Because what you've done is that you have set yourself on tangents that may not be helpful, because the adverse party is either going to request for further and better particulars, as we all know, or bring an application for disclosure. Again, that is for the application. Now, even that is for you who's preparing your paperwork. The person who is also applying for production of documents also very often I see fall into errors, embarking on fishing expeditions. They want to see everything that you have. And it's probably not helped by the fact that you have pleaded in a particular way by saying, oh, we'll rely on any and every document that is relevant. What does that mean? So if your adverse party brings an application to say, give me everything, it comes across as a fishing expedition. What that does is that it derails the case. So that's one area where I see that the fault are. In more complex disputes, like engineering disputes, you have documents that are missing, there are emails here and there are emails there. You need to know your case very well, and don't reference documents that are far removed from the bundles that you have in your office that you're working with. And you must always learn to ask. That I would say for now about document production, unless something comes up, because I want to jump into I think you said witness statements and I think cross-examination. The thing about witness statements is the problem again I see is over-lawyering, copy and pasting. Very often you see that a statement of claim or a defense is worded in a particular way. And then you look at the witness statements, it's just a copy and paste of the witness statement. And then when you get to the full evidentiary hearing, the light bulb moment comes and counsel realizes that, oh, we didn't include this in the witness statement and now wants to make it the subject of an oral examination. Witness statements are your typical examination in chief, in which you make copious reference to the evidence that you have basically pleaded, and you substantiate and elaborate more on the factual matrix that you rely upon. So in that space, I see very often many counsel fall into errors. An example is even where it comes to hearsay. You decide that you want to call only one witness, but that one witness may not be able to testify satisfactorily to all aspects of the case. If you need to separate by having other witnesses, by all means, you need to. Do not say that simply because the Evidence Act does not apply and I do not have to follow the strict rules of evidence, therefore, one witness can say everything. One, when that witness gets into the box, the witness will be scandalized and embarrassed by questions that come under cross-examination because you don't want to appear as though you're ignorant. And like I said earlier, there are certain basic rules that govern us, even in day-to-day conversations, that are more of your typical evidential rules. Let's not forget that this Evidence Act that is self-exclusionary, this same Evidence Act that doesn't apply in arbitration, is actually a codification of a body of rules that had evolved over time. And so even though they strictly do not apply, it is intended to put the arbitrator in the driver's seat to be able to allow certain things that he feels would be allowable in the circumstances. And I just jump straight to cross-examination. I see that there is also a lack of understanding of what cross-examination is intended to achieve. First of all, the thing counsel needs to do is to prepare. Prepare your question, adequately prepare. What do I mean by adequate preparation? Know your own case very well. You will have heard it said that the golden rule of cross-examination is never to ask a question when you do not know the answer. But what I do observe in practice is you have many counsel that feel that they have a one-size-fits-all approach. I must be aggressive, regardless of the witness. I must be aggressive. And so they tend to be aggressive to the witness that actually came to cooperate with them. So, and the witness gets tipped off and then makes it a frustrating experience for counsel. What I always encourage is assess your witness. You may not know the witness before you get into the hearing room. However, this is the place where your preliminary questions matter to assess. And I'll give a quick example. I once had an experience where I had to cross-examine the leader of a criminal investigation, the one who prepared and signed the report in respect of a gap that I had seen. Looking at the report, the gentleman I felt was a Muslim. So I took it for granted that he's a Muslim because he had a strong Muslim name, the kind of name that you hear and you have no doubt in your mind that the gentleman is a Muslim. Then he gets into the box and they ask him, are you a Christian or a Muslim? And he says, I'm a Christian. Now that piqued my attention immediately. He says, I'm a Christian. Now says, would you want to affirm or would you want to swear? And he says, I will swear. That took it to another level for me. So when I started my examination, I explored that a bit more. And he said, yes, he converted to Christianity. And I said, your convictions are, you must be a man of conviction. That's why you want to swear. And he said, oh, yes. So my next point to him is that you will not want to see an innocent man go to jail. And that marked the beginning of a very cordial cross-examination, as opposed to the cross-examination of somebody that came to stonewall. So you need to assess your witness very well and adapt. You must have your set of questions, but you have to be ready to adapt it to suit the particular witness. And please note, it is not a must that you have to cross-examine somebody. There are times the witness has not given any evidence that damages your case. You need to listen to the evidence very well and determine whether or not you need to cross-examine. And if you must cross-examine, determine the scope of your cross-examination, because very often counsel tend to ask that one question too many. And that knocks the bottom of the tower that has been built under cross-examination. I hope I've been able to skim through everything, but I don't think we can totally exhaust it here. But I'm hoping I have been able to do that.
Yes, thank you very much, sir. You've touched on quite a bit. In the course of your response regarding documents, one of the things that came to mind is that counsel preparing should anticipate matters of disclosure when preparing pleadings, so that you already know that this is likely to happen. They would likely ask for this, and you can already make that available to save everyone's time and move the process along quicker. Now, still on the documents issue, because I mean, documents tend to form the chunk of what would be presented as evidence at hearings. How should tribunals handle situations where key documents or facts are primarily within the control of one party, particularly in government or oil and gas related disputes?
That is very, very tricky. It's an everyday situation we encounter. And first thing to do as a tribunal is to issue clear procedural orders, because you wanting certain documents and you wanting some kind of direction in respect of how you get it emanates from what you have in the procedural orders. So the tribunal must take control make those orders. But I know that by saying that, I'm merely sounding cliche, because yes, there will have been procedural orders. We're talking about the problems you encounter not complying with the procedural orders of the tribunal. So you do have those situations where, whether it's as government tells you it's a security document or documents relating to accounts or royalties or profits, since you're talking about the oil and gas industry. First thing I believe should be done, which I as a tribunal will do, is to give assurances to the parties. Assurances about proper balancing. So what do I mean? The first thing parties need to understand from me is that the arbitral process is not just private, it is also confidential. And that confidentiality attaches to every document that is presented in the arbitration. The other thing to do is, when you give that assurance, you try to see if the party in question responds well to that. The other level you may want to go to is if the document is the party is so particular about releasing that document, you may also want to say to yourself, could we have a small in-camera disclosure, whether we can adapt, because we know that in the event of an award being rendered, some people might end up in court. Now, of course, at that stage, the evidence is no longer relevant. It's just the award and the contract resulting in the arbitration. But we've seen in court where, in spite of those rules, many a counsel will still bring in evidence. They are challenging evidence, and they basically are looking for a rehearing, so taking it as an appeal. While that may not be right, the fact of the matter is that it is already there and the documents are now in public domain. So you may be concerned that in the event that this award goes one way or another, that document may still find itself into the public domain. In that situation, you may say, can we have a private meeting? Maybe we want to redact aspects of the document or whatever. Those are the things that you might want to introduce as a tribunal. But I don't think it should get to that level, because the privacy and confidentiality conditions attached generally to arbitration documents and documents used in there. Speaking specifically to the oil and gas industry, one thing I've come to find is Section 83 of the Petroleum Industry Act 2021, which talks about transparency and openness. It talks about transparency and openness. So those documents can be there. So it already states that you shouldn't be hiding any documents, particularly relating to the contracts in issue. As a matter of fact, they're supposed to even be in public on the website, published online. Now, if there is a document you're looking for that does not have a publication online, then you can ask for it. And I think a tribunal will be well within its remit to say, look, relying on this section, this document should be produced and be given to you. But let's look at the worst case scenario. Of course, I should mention that there is also the Freedom of Information Act, even though you don't want to find yourself in that place, citing laws, and people need to respect the process they have chosen, which again, at the risk of being repetitive, is private and confidential, and those virtues attach to those documents. But in the worst case scenario, the need or possibility of drawing an relief from what you have in your Evidence Act, I think the old section 149D, which says if the party is required to produce a document and does not produce it, it is assumed that the reason the party has failed to produce those documents is because the evidence would not be in that party's favor. So you can draw adverse inferences in that situation. But by and large, I think it starts with, call it moral suasion, call it what you will. It's a convivial atmosphere. So you should be able to speak with each other about how to handle confidential and privileged documents, and the tribunal can step in how it can be done, but that you would not use it in the reference. If it is critical to the determination of a fact in issue, that should not be.
All right, thank you, sir. Before I move on to my next question, I want to quickly recognize and appreciate members of council of SBL who are present. We have a chair who spoke earlier, Mrs. Ozofulatunde Ogemudia, Secretary of Council, Mrs. Ayoyinka Olajide Awosedo, Mr. Desmond Ogba, Mr. Rotimi Ogunyemi, and other members of council, as well as members, the chair and members of the board of the Chartered Institute of Arbitrators Nigeria. Thank you very much for being with us this afternoon. We would like for this to be as interactive as possible. So for our dear attendees, if you have any questions that you would like to be discussed, you can drop them in the chat or in the Q&A box, and we'll try to take them and get our speaker's perspective on your questions. So coming back to where we left off, sir, you ended with talking about adverse inferences. So I want to ask, how comfortable are tribunals seated in Nigeria with drawing adverse inferences? And where should the line be drawn to avoid breaching fair hearing principles?
Sorry, I don't know if it's me or you. I struggle to hear the question you asked.
Okay, I asked, I said where you left off, we were talking about adverse inferences. You mentioned...
Femi, please, could you tell me if my network is failing or it's from your end? I don't know. Can you hear me?
I can hear you clearly. I can hear you clearly, sir. Okay. Sorry, please, can you just help me repeat the question again?
Okay,
so I said that in concluding your response to the last question, you mentioned adverse inferences that can be drawn from relying on the old Evidence Act, which to be Section 149, as you mentioned. So my question is, how comfortable are tribunals seated in Nigeria with drawing adverse inferences? And where should the line be drawn to avoid breaching fair hearing principles? Did you get that, sir?
So yes, I did, Femi. Yes, I did. It was a bit, there was a bit of a glitch, but I think I get a sense of your question. Now, generally, tribunals will not, or let me speak for myself, I will not be quick to draw an adverse inference from the mere failure to produce the document. The first thing, I will always be cautious, because when you draw adverse inference, there is a due process question that underlies it. And it's always a question whether you have not violated due process concerns. But as a tribunal, I have, much as I'll be cautious in doing it, I have absolutely no problems drawing an adverse inference. The more important thing for me to do is to be sure that in the circumstances of the case, I should draw adverse inference. And how do I assure myself? There are some practical considerations that I'll typically make. Number one is I will give that party ample opportunity to produce the document. It won't be a first, it will not be a second, it might not, I mean, it depends on the case, but at the very least, I would have given ample opportunity. Ample opportunity will be defined by reference to the peculiarities of a given case. But I will give ample opportunity for the party to produce the document. Number two, I will be talking, if I'm going to draw adverse inference, I will ensure that drawing adverse inference, I'm not just throwing it in to take the place of the primary obligation that a party has to prove its case. So, a little explanation. There is a burden of proof on a particular party. He now needs some document from the adverse party, which the adverse party, for one reason or the other, is failing to produce. What I'm saying is that he still has that burden to discharge. It is only when we have come to a finding that that document is decisive of a fact in issue and it has not been produced, that we can start talking about adverse inference being drawn. But the main obligation that that party has to prove the other collateral circumstances will not change, because in doing that, the existence or non-existence of that document be totally irrelevant at the end of the day, especially if without drawing an adverse inference, you can make a determination on the evidence that is otherwise produced. But you have to be very careful. It doesn't remove that primary obligation. You also want to restrict it to the fact in issue. So if that document is relevant, it is relevant to what? Now, when you have all these considerations as a tribunal, you will then be transparent in saying, look, this and this and this are the circumstances that play out. This is the relevance of this document. This is what this document would have done. A, B, C, and D are the steps that the tribunal took to have this party bring it. Unfortunately, for inexplicable reasons that remain inexplicable, the party has failed to do so. The tribunal is left with no option but to assume that the reason the party did not present it is because the evidence would have gone the other way against the party. So I think tribunals, to answer your question pointedly, don't have a problem drawing adverse inference. I think the more what they do is to impose a stronger, responsibility, a heavier responsibility on themselves to make sure that they only do it when they have to do it, and because they don't want to violate due process concerns.
All right. Thank you, sir. We're actually pressed for time now. They say time flies by when you're having fun. I'm actually enjoying this quite a lot, and I know quite a lot of our attendees are also learning from you, sir. We have a couple of questions in the Q&A box, which I would come to momentarily. Arbitration is a party-driven process, and the advantages which make it attractive to disputants include privacy, confidentiality, and speed. So with the push for faster and more cost-effective arbitration, is evidentiary rigor being compromised, or are tribunals simply becoming more pragmatic in dealing with arbitral references?
I believe the answer to that is being more pragmatic, but not at the expense of evidential rigor. There is an English case, it's a tongue twister, it's the Arab African Energy Corporation case, where the judge stated, and I quote, "Commercial pragmatism, not legal accuracy, is the preference of men of commerce." Commercial pragmatism, not legal accuracy, is the preference of men of commerce. You need to understand first and foremost that an award and a judgment are not the same. The standards that are expected are not the same. You are not a judge when you are sitting as an arbitrator, so you don't embark on expositions and disquisitions of the law. You are basically speaking differently, because your duty is to write a reasoned and enforceable award. So in my view, the evidentiary rigor is in no way being compromised. But you've got to also understand that the origins of arbitration did not even include lawyers in the first instance. It was just men of commerce who felt that we needed a more expedient and faster way to, a more efficient, not necessarily faster way, to resolve the dispute in arbitration. Arbitration is slightly more nuanced than litigation, and so you've got to understand the fundamentals of it. It is issue focused. If you're dealing with an evidential issue, there are many tools that you can deploy to cross those Rubicons that ordinarily would ensure that the matter is delayed, linger for a long time, and might then be misconstrued if you move on and they say, oh, evidence was supposed to have been led, but the man was intending to be just too fast about it and did not do so. And then they begin to raise due process concerns. My take on it is that pragmatism is very key, but not at the expense of proper evidentiary burdens being discharged. So you deploy the necessary tools while you're trying to move a process fast, while you're trying to get to destination, yes, quickly. You ensure you deploy tools in the process to enable the speed and also appreciation of the evidence, like the Redfern schedule in arbitration, which is a tabularized way of dealing with discovery matters. You give directions that help to streamline. You have parties formulate issues early enough when pleadings are closed. You see how you can marry the issues together. You, as a tribunal, give directions as to how the process should go. And I think if you do that, you're being pragmatic and you're also being mindful of the need for the discharge of the evidential burden.
All right, thank you, sir. So commercial pragmatism, not legal accuracy, but it must not, however, be at the expense of evidence and evidentiary rigor. We have a couple of questions in the Q&A box. Let me quickly take one of them. So Victoria Jonah is asking, will a document that is deemed to have been dumped on the tribunal by counsel be reckoned with when writing the arbitral award, when the tribunal is writing the award?
Like I said earlier on, as a tribunal, you will go through all those documents. But when you're writing your award, and this is one thing you will find in a number of awards of experienced arbitrators, you don't always have to mention every document to a T. Your duty is to consider the evidence. If you bundle and throw a set of documents at a tribunal, the tribunal will read it and will determine its relevance. But the issue is not so much about putting it on the tribunal's head. It's about the consequences of doing so. Because if you do that, the tribunal will reckon with it if it sees that it is relevant. But the tribunal may see it's not relevant and you think it is relevant. But at what stage do you want to now make that point? You'll be locking the stable after the horse has bolted. So your duty is not to just expect the tribunal to read it, but for you to ensure that you draw the tribunal's attention to that document. Then you could say that you have discharged the burden. I think it's a bit of, for want of better words, it's a bit lazy not to do what you should do. Look at the procedural order. Tribunals always stipulate it is your responsibility and discharge that duty yourself.
All right, thank you, sir. Because of time, I would hit you with two questions quickly. Give maybe a minute and a half to answer each one. So firstly, the first one, we mentioned this earlier in passing, referred to the IBA rules on evidence. So in your opinion, do the IBA rules on evidence meaningfully shape arbitral outcomes in Nigeria? Or are they more of a procedural reference point than a decisive tool?
Okay, so first of all, understand that the IBA rules is soft law. It's not hard law, it's soft law. And it is only decisive to the extent that parties have chosen in agreement to adopt them as the basic evidential rules to apply in the arbitration. So are they decisive? It is only to the extent that parties make it so. The rules are such that you can adopt the whole entirety of it or parts of the rules. So that is the answer that I'll just give. But generally, you also must understand that the local statutes are very key. For example, the Arbitration and Mediation Act, Section 31 deals with these things. It states you can choose the rules you want, but when it comes to matters of evidence, matters of admissibility, compellability, relevancy are to be determined by the tribunal. So where the IBA rules may not be consistent with what is going on in the hearing, the tribunal still will step in. So can they be decisive? It is only to the extent that the parties make them so decisive. I hope I did that in less than a minute.
Yes, sir. Thank you. Thank you. I think you helped to keep it within the time, although I know it's something that you'd have gone on in more detail about. Looking forward, do you see Nigerian arbitration practice developing a distinct approach to evidence and burden of proof, or continuing to borrow heavily from international norms, both already existing and in the future?
I see a combination of both. I see a combination of both. So if we look at Nigerian arbitration practice, our Arbitration and Mediation Act is greatly influenced by the UNCITRAL model law, 2006, and perhaps now getting to an amendment. Now, UNCITRAL model law, UNCITRAL, as you all know, or I assume you know, is United Nations Commission for International Trade Law. They evolve a body of laws that should guide our domestic laws. And so it's an international document. There is the case law digest of UNCITRAL, which basically deals with cases that have come up in different jurisdictions regarding certain clauses of the UNCITRAL model law. So typically, if a Nigerian court is faced with the need to interpret a particular clause in the Arbitration and Mediation Act, and there is no local precedent for it, it will typically make reference to this case law digest or the UNCITRAL notes, the notes that the conversations that informed that enactment in the first place. So to that extent, you cannot extricate yourself from the foreign norms and all that. You will always have that. But then, if you look at the Arbitration and Mediation Act, there are certain innovative provisions that we have put there. For example, the Arbitration Appeal Tribunal. Those ones are there. We need to develop our own body of jurisprudence in that way. So, like I said, it's a combination of both. But you've got to be mindful. If you take too much of the foreign norms, what you do is that you isolate the Nigerian legal culture, and it becomes detached and far removed from the Committee of Nations. At the same time, if you decide to stay fastidious about localizing your rules and not internationalizing them, you will again find that our system is unpredictable. My motto and my mantra has always been, think globally, but act locally. Let your standard be a standard that runs across board. An award that is given in a domestic arbitration must be able to stand the test and scrutiny in a foreign country. And that only happens because the UNCITRAL model law is a standard by which a lot of countries have used to form their arbitration laws. And so what you're applying here, the principles as you discuss them here, is 9 times out of 10 the same principles that they discuss in a place like Lusaka or Ghana or wherever else, with differences to meet the peculiarities of the environment in question.
Thank you so very much, sir. We have still the number of questions in the chat box, but we have indeed run out of time on this session, and it would be remiss of me to carry on despite how engaging this is. I know that for many of our attendees, we have learned quite a bit. So I want to thank you very much for your time, sir. And
can I jump in, Femi, and appeal that we have 2 of those questions, if it's not too much, if it's not an imposition. I know that I can be wordy, but I think it's good that the questions that are asked also come from the audience. I know you've taken one, but it's up to you. But I just feel, because I also want to pick certain things that they may see that I have not seen.
well, let me ask for
It's
permission from Madam Chair.
I don't want to intrude.
All right, I have been given approval to proceed. So thank you very much, Madam Chair. So let me bring this up then. There's one of the questions we have says, is there any consequence on an award if a party fails to file a witness statement along with its bundle of documents in a documents-only reference, even though same was agreed by the parties and ordered to be filed by the tribunal? Did you get that, sir?
It's a contradiction in terms. If it's a document-only reference, you're not talking about witness statements. I'm a bit confused. Harry, you may need to explain that. I'm not too sure I get that question. But if it's a document-only reference in which parties are not talking about contested facts and figures or whatever, then you're leaving it to the tribunal to interpret the documents. I'm not sure that the witness statement would be of any significance in that situation. And that's what readily comes to me. But if I have missed the point, please feel free to clarify the question. But I think it's a contradiction in terms to expect that evidence, which is what your witness statement is going to be, especially if it's going to be contested, will now become relevant in a documents-only context. I think it's more of the arguments of counsel that matter.
Well, all right. So another question here says, where a tribunal, as a follow-up question regarding drawing adverse inferences, says where a tribunal orders the production of a document and the adverse party default, citing both non-possession and a lack of relevance, can the requesting party bring an application to the tribunal to draw an adverse inference?
It's, in my experience, it's not an application matter. It's when the hearing is going on. To start with, if a party says the document is not relevant, that is down to that party's thinking. If you tell me that a document is not relevant, the relevancy, the law says it's for me as a tribunal to determine. And I can only determine its relevance when I see the document. If you don't produce it, how will I know? So that is a cop-out for such a party. And you have actually set yourself up for the tribunal to readily draw an adverse inference. That you don't have it with you is a custody issue. You will not be asked, an adverse inference will not be drawn in respect of something that could never have been with you or you are incapable of producing. The whole fulcrum on which it rests is that the document is with you and it is for you to produce it.
Thank you, sir. One more so that we can close the session shortly. This is a bit general, but I'll take it. Where parties to an arbitration agreement provide, for instance, the site is given an example, that Lagos state law shall be the applicable law. Does this choice govern only the substantive contract, or does it also determine the procedural law of the arbitration, considering the Arbitration and Mediation Act 2023?
Okay, so I'll try to. So the answer is no, it doesn't necessarily determine it because the parties have to make a choice. You've got to make a distinction between the applicable law and the procedural law. So potentially, and let me just try to dive in, there are potentially 5 legislative regimes that may affect an international arbitration. Potentially, they don't necessarily apply. But you need to have them, even if it is a jurisprudential distinction. So if you're going to contract with somebody, one of the laws that you typically think about is the capacity of the person to contract in the first place. So that's the law that deals with capacity. Now you enter into a contract. There is obligations to be met. There are clauses that prescribe obligations for parties. There is a law that governs that. That there is the applicable law of the contract, the law that governs the substantive rights of the parties. That is number 2. Then you decide that, all right, in the event of a dispute, we want to go to arbitration. And by reason of what you call the doctrine of separability, that arbitration clause stands independent of the contract in which it is embedded. So let's say it is in clause 17. Clause 17 is thereby by reason of that doctrine, treated as a contract within a contract. And since it is a contract, it also is subject to its own law, meaning that there is also the law that governs the interpretation of the contract, of the agreements to arbitrate. Now, when you go into the arbitration room, there is the law that has to govern that arbitration itself, which in this case is the Arbitration and Mediation Act. So that is the law, that is the procedural law that governs the arbitration. So you see, I've given you 4 now, but the arbitration is about when that award is given and one party decides not to comply, you typically want to go to court to enforce it. Now, your court may be Nigeria, it may be elsewhere. So you also think about the 5th, which is the law that governs the place where the award will be enforced. So you have to think about this. But to your question pointedly, Lagos, in that sense, will be applying to the law itself that governs the obligation of the parties. That's the expression, that's what you mean when you talk about the applicable law. So that's it. I hope I did not rush through that too much. It can be a bit of a mouthful.
Well, I believe that attendee, gotten the answer to his question.
Did you understand it?
Yes, I actually did.
Good.
I actually did. Thank you so much. So, well, on behalf of the committee, the Arbitration and ADR Committee of the NBASBL, led by our chair, Mrs. Oibiovia, I want to thank you for coming. I am just saying this on behalf of the committee. The proper vote of thanks will be handled and be taken momentarily by the Secretary of Council, Mrs. Ayoyinka Olajide Ausedo. And you'll please forgive me. I hope he forgives me too. I made an error of omission earlier while recognizing our members present. I want to especially recognize and appreciate the immediate past chairman of the Arbitration and ADR Committee of the NBASBL, Mr. Ladipo Shoeton, FCIAB. He did most of the groundwork in putting this together before his tenure ended at the end of January. So I want to thank you very much. I will now hand over to the Secretary of Council, Mrs. Ayoyinka Olajide Ausedo, to take the vote of thanks. Madam Secretary. Is Madam Secretary still on the call? It appears not. May I conscript Mr. Rotimi Ogunyemi to do that on our behalf, please? Mr. Ogunyemi, are you able to talk, sir? Oh dear.
I think you're your own.
I'm wondering, and it's a bit concerning. Have I been left on my own?
But it is fine.
Maybe the chair of the
fine.
arbitration committee can do it.
Mrs. Ovia is currently airborne.
Okay, her.
She's airborne and unable to speak.
Okay. Well, I'm still here.
Well, so Madam Chair of Council, can we put that on you?
Okay. Yes, of course. I would like to, on behalf of the Executive Committee of the NBASBL, I'd like to thank the Leonard Silk for all he has shared with us in 1 hour plus. I'd also like to thank our moderator, Mr. Nokoya, and back again to my fellow chair, Mrs. Adigbomire, for this collaboration. I'd
Thank
like
you
to,
very much.
and looking forward to doing a lot more physical events, other events, written articles, all sorts that we can do together. Thank you to our audience. We still have 348 people. That says a lot. So thank you to our faculty. Thank you to our audience. Thank you to the teams that worked on this behind the scene. Enjoy the rest of your day. Thanks, everyone.
Please, can
Bye-bye.
I just add that we're happy to also collaborate on trainings, and because we're doing it together, we will be happy. I mean, Mr. Sheila Ojo is in charge, but I believe that I can speak on his behalf to say we'll even be happy to offer discounts because we are now working together. Mr. Sheila Ojo, do I have the permission?
Thank you so much.
Next look.
I think the head of an elephant is not load for a small child like me. Madam Chair, you are the one that takes the decision. So please don't throw me under the bus here. But I think she speaks for every one of us.
We want to collaborate with you in every way.
Yeah.
This has been wonderful.
It's about the knowledge is about knowledge sharing. And
yes,
we're more than happy as a branch to lend ourselves to that process.
Yes, we want to collaborate in every way. Thank you so much. This has been a very good beginning.
Yes. Thank you. Thanks, everyone, and enjoy the rest of your day. Bye-bye.
Bye-bye.
Thank you, Madam Chair. Good afternoon, everyone.
Good afternoon. Thank you so much. Great job.
Thank you, ma'am. Bye-bye now.
Bye-bye.